Okay, sorry about that. I just had to, I always forget to record. If anyone ever wants to remind me, feel free. So learning objectives this week. Make sure you just really keep track of these. What's administrative discretion? What's statutory detail? What's the process and importance of rulemaking? And then what's the APA, the standards for rulemaking and judicial reviews? There's a lot of content this week, and it's pretty advanced. So take your time with it. The most important thing to know is that rulemaking is the process that agencies use to clarify how they're going to interpret laws from Congress. I'm going to go ahead and go to a fuller screen here. In the context of our class, when I say administrative agencies, I'm referring to the federal agencies. So these are agencies that basically administer the law, and that's why they get that name. And the reason we talk about rulemaking in this class is because like most natural resource questions are actually solved through rulemaking. They're like agency interpretations of existing laws that have been on the books for a long time. So laws like the National Forest Management Act, which is really vague in general, and the Forest Service under that law can ban road building, or they can promote a ton of timber harvest, or they can decide to promote climate change or not address it. The law leaves all this room for interpretation, and it's through the rulemaking process that agencies make most of the important decisions. So things like, you know, should we list or delist grizzly bears? Should we reintroduce wolf populations? Should we allow snowmobiles in Yellowstone National Park? All these questions are often dealt with through the rulemaking process. Now, I'm just gonna...
So let's start by talking about rulemaking generally. Rulemaking is a process that the federal agencies
is that me?
use to clarify.
Hold on. I was like, who's talking? Okay, so there's a few things that I want you guys to know. You can check this out, but laws are generally pretty vague. Here's an example from the multiple use mandate for the Forest Service. It's a law from Congress, and it just says national forests are to be administered for all of these purposes in a combination that will meet the needs of the people, not necessarily the combination that's going to give you the greatest dollar return. This was written back in the 60s. It's still law. It leaves a lot of room for interpretation. Now, I have a question here for you guys. Can you look at these bullets on the multiple use mandate, and can you see here like what might be vague? Can anyone, I guess, share with us, or you could unmute yourself, like what might be sort of interpreted differently by like a different president? Or where would you have questions if you were the Forest Service about how this could be interpreted? Does anyone see any kind of ambiguity in here? I'm pausing.
Outdoor recreation and like the multi-use purposes, like what's the definitive line for those things, because that can be very kind of transparent and go multiple ways.
Yeah, is that Susan?
Yeah, sorry.
Yeah, so Susan, like one question you might have is like, well, on a national forest, like how do I balance all these things? Do I have to do all of them on every national forest? Can I say this national forest is all about timber and another one's all about recreation? All of those kinds of questions are like kind of left open by the law, you know, like who gets to define what's the needs of the people? Are we talking about the local people or the whole, all the people? Does anyone else have any thoughts on this, on what's kind of vague in this?
With the ambiguity of that, is there a balancing act or a percentage designation for the total park mass area? Do they need to divide it between different uses or purposes in a segmented way, or is it just up to the discretion of local lawmakers or immediate area interaction?
Yeah, so Sean, this is a great question, because essentially what you're asking is like the question they have to answer in rulemaking is the agency, the Forest Service, would have to clarify how they're going to interpret this. And that's what's required in the rulemaking process, is that they now have to put out regulations that clarify how they interpret this. Like, are they going to do all of these on every forest? Are they going to do it as long as it doesn't compromise ecological sustainability? You know, are they going to even consider climate change when they do this? I mean, those are all the questions that they now have to answer in rulemaking. And what happens is every agency puts out different rules, like with almost every presidency, they'll change the rules to say, okay, here's how we're interpreting this law now under this president. Let me just share a few more things about,
The reason this happens
oh
is
my
because
gosh,
the
sorry, I'm just learning how to use all of this. I'm going to skip this because you guys will hear about it. But there's 3 reasons Congress writes really vague statutes. And I think, Michael, you asked about this. One reason they do this is because they know that the agencies are the experts. So they say, like, we're not going to write a detailed statute about how to do forest management. We're going to write a general statute, and then we expect the Forest Service to figure out, you know, they're the experts. They can draw on their scientific expertise. They can update how they're interpreting it over time. The other thing, the pluralist explanation is just that laws have to be vague in order to get passed in Congress. There's so much bargaining and compromise that has to happen. By the time they pass a law, it's got to be pretty vague. And then the other reason is this public choice explanation that, like, they don't want to make risky decisions in Congress. So they just kind of say something very general that'll please everybody. And then they let the agencies make the tough decisions, like how much timber are we going to harvest here? How much recreation are we going to allow? Are we going to protect these endangered species? So it's almost like they pass the buck to keep it easy for themselves. Let me just tell you a few more things and then we'll take some questions. So rulemaking is this process of making administrative law. It's also, rules or regulations are synonymous terms. Rulemaking is like the process that agencies use to interpret law, and then they create these rules and regulations. And so when you have statutory ambiguity, you leave a lot of policy decisions to the agencies, and they have a lot of room to do that interpretation. This last point's what's really important. Rulemaking is that process where agencies make administrative law and they write regulations. And what they're doing is they're clarifying how they're going to, what's their intent, how are they going to interpret the laws, how are they going to implement them. And just keep in mind that the more vague a law is, the more ambiguous it is, the more room there is for the agency to kind of swing their interpretation from one president to the next. I mean, you guys can imagine, like, we're going to look at some examples today, but the way like Trump has interpreted environmental law has been much more relaxed than the way Obama interpreted environmental law, and it changes from president to president. I think that is the end of that first little overview of rulemaking. So let's see, I couldn't see your comments while I was screen sharing, but I'm back now. But I'm curious if anyone has any questions or comments on just kind of that quick overview of like what rulemaking even is. Do you just want to look at some examples? Would that be helpful? Yeah, let's do that. Okay. Janae, you had a question here. Oh, you're just talking about like the ambiguity in that law. Yeah, I appreciate that. All right, I'm going to paste in the chat box for you all a couple articles. And so I want you to just all pick one. So this first one, we're not going to do breakout groups today. We're just going to work independently because I know some of you all don't love breakout groups. This first one is, well, maybe we'll do short breakout group because some of you want to meet each other. So we'll do a really short one. But this first article is about like all the different rules that the Trump administration has kind of undone or rolled back. So it's an interesting article, but I also found some specific ones if you are interested in checking them out. Hold on, I'm going to give you a few other examples you can look at. Okay, this one that I'm posting is about the Endangered Species Act rule changes that the Trump administration just proposed recently. This next one I'm posting is about mercury regulations. The Trump administration has changed the rules to allow more mercury in the air from power plants. And then I'll post one more here that you can look at. And this one is about their rollback on light bulbs and not requiring energy efficient light bulbs. So again, there's 4 links here, and one is about kind of all of the different rule changes the Trump administration has done. The second one's about changes to the Endangered Species Act. The third is about mercury, and the fourth is about light bulbs. So I want you to pick one of these articles, and for any rule change, you want to try to figure out a few things. So figure out, if you can, it's not always easy, what law the rule is interpreting, because every rule is interpreting a law. What agency is in charge of interpreting that law, and then like what's basically the content or the meaning of the rule change. So pick one of these and look at it, and then let me see, do you guys want to do breakout groups today, or do you not want to? Let me see thumbs up or thumbs down. Breakout groups, yes. Just so you could say hi to one other person. Okay, we'll just do a quick 5-minute breakout so you can meet like someone else, but work on this on your own first for about 10 minutes, find an article and see if you can answer these questions. And I'm going to tell you that for some of these articles, you cannot find the answer to these questions. It's really hard to figure out like what law is being interpreted and what agency is in charge. But take a look, see what you can figure out, and then we'll just do a quick discussion in a breakout group. Okay, you guys, I'm just going to give you a few minutes in breakout rooms to just talk to a couple other people about your article and see if you can answer those questions and maybe help each other clarify what's going on. And then we're going to come back and try to talk about a couple examples. And then also, if you all have any questions about rulemaking you want to go over, you might want to clarify those. And so I'm going to put you in pretty small rooms. So there should just be 2 to 3 of you there per room, and we'll just do about 5 minutes. Hey everyone, welcome back. So I'm wondering if anyone would someone volunteer to start us off with the Endangered Species Act one? And can you tell us anything about like what agencies involved, what laws involved, and what the regulatory change is about? And then if other people looked at that one, they can kind of add on to it. But would someone start us off and just take a stab at it?
I could.
Okay, Emma, go ahead.
So essentially, the Endangered Species Act was passed by Congress under, oh God, was it Nixon or Reagan?
Nixon in 1973.
By Nixon, and then it's since been taken under the wings of the U.S. Fish and Wildlife Service and some other environmental agencies, and it's based more on how I see it as like they do it more of like a habitat range and what lives within there and how that relates to certain species being infected by X, Y, and Z conditions that make it harder to survive in their habitat. And the reason why the sort of laxing of the ESA standards that the Trump administration has proposed is so startling is because it really kind of undermines the ability to protect the species under the Endangered Species Act. It makes it harder to get species onto the list, and it has called into question a lot of the species of why they're even on the list to begin with. So it's kind of like changed up the standard of why a species should be protected, which is very disconcerting given like climate change and degradation that continues to occur.
So let me just pause there and take a look at the chat box, everybody. So what Emma's talking about is this rule change, like it's a rulemaking that's happening under the Trump administration. And the way you want to articulate this, because these things are hard to talk about when they're new, is that the U.S. Fish and Wildlife Service, they're the agency that administers the Endangered Species Act. And the act was passed by Congress, and they administer it on land and for freshwater species. And then NOAA Fisheries is the agency that administers the Endangered Species Act for saltwater species and anadromous species, which are species that migrate from salt to freshwater like salmon. And so those are the agencies that basically implement the law from Congress, and they because they're part of the executive branch. They ultimately work for President Trump, and they get to do rulemaking under the law. And so the article on the Endangered Species Act is showing how the Trump administration is weakening the act. They're shrinking the definition of how habitat is defined for the species, and they're making it harder to list species. Now, Emma, you're talking about why that concerns you from a conservation perspective. Who do you think would like that? Like, who in the country is going to support weakening the Endangered Species Act? What is the argument on the other side? Can someone else talk about like what the argument on the other side might be for reducing the power of the Endangered Species Act?
I can talk about it.
Who's that?
That's me, William Eager.
Okay, William, talk about that a little bit. What's that like alternative perspective?
The other alternative perspective, I know it's a big thing with burrowing owls that they that there's a lot of places where they want to do real estate development and what do you call it, just increase property value, and these properties are completely frozen and unable to be what do you call it, modified or enhanced for what do you call it, our economic reasons. Are just they're what do you call it, forced to be left alone because of the Endangered Species Act, that we can't interact, we can't destroy, and we just can't touch these protected lands because of the species living on them.
Yeah, so one of the arguments is that the Endangered Species Act can limit development, and sometimes people who are arguing that it should be weaker, they're making that argument. They're either thinking we should have less protection of some of these species. Like some people are like, why would we protect, like there's a species called the Delhi Sands flower-loving fly in Southern California that like people are like, why are we protecting this fly? But the other argument people will make is that maybe it should be left up more to like local jurisdictions, like states or local government, and not be the federal government coming in and doing it. So there's a lot of arguments on both sides. And we could talk about that more, but generally, I think it's important to think about like what would be the arguments and counter arguments. But generally, the changes that the Trump administration is making are pro big business, or they're pro development, or they're reducing the power of the federal government, because you know those are the things that the Trump administration has run on and has support for. So keep that in mind. Now, what about the light bulb one? Did anyone read that one? And can you tell us about that one? What is the Trump administration doing with light bulbs? Did anyone read it?
It was blocked for me.
Oh, you've read too many New York Times articles, Carl.
I don't know. One of them worked, but then the other two didn't work, so.
Well, did anyone else read the light bulb one? I think it's pretty funny because in there, Trump talks about just how he looks better under certain kinds of lighting, but the like, which is kind of amusing. He talks about some light bulbs just make you look better. But in general, which is true, I think. But that one's about how like there was a law passed during the Bush administration, the George W. Bush administration, that's about energy efficiency. And so I think the Bush presidency and Obama had like increased standards for light bulbs to be more efficient, and the Trump administration rolled those back. So they did rulemaking to basically say, no, under that law, we're not going to require light bulbs to be more efficient. Everyone should be able to choose their own light bulbs. And if you have like old light bulbs you want to sell, they don't want to stop you. Sometimes this stuff doesn't matter because like the light bulb industry is moving towards efficient light bulbs, and that's what people want. So sometimes rulemaking doesn't have a huge impact, but that's another example of it under the Trump administration. And it's another example of like an anti-energy efficiency approach. Did anyone read any of the other articles that you could tell us about? Please, one more person, just for fun.
I read the mercury like restriction rollbacks.
Yeah, so Carolyn, what's going on there? Could you figure out what agency was doing it and what law they were dealing with it under and what the content was?
So the law that they are undermining is the EPA, that has like restrictions on emissions and toxic pollutants that like companies are allowed to release into the air. And I didn't see exactly what like agency is, maybe like the Chamber of Commerce supports it, of course.
So that the EPA, the Environmental Protection Agency, is actually the agency that is doing the rulemaking. So they're the agency that works for Trump. That's like revising the regulations. And so the question then is like, what law are they interpreting? And I wasn't sure I could figure it out from that article.
Yeah, I didn't see like the main law that it's undermining, but it's really just setting the stage for more fossil fuel companies to be able to challenge restrictions. And it says that is the big unstated goal. This is less about mercury than about potentially constraining or handcuffing future efforts by the EPA to regulate air pollution.
Okay.
So he's just setting the stage for like coal and fossil fuel industries to challenge that and to not have to even like report a lot of their emissions. It really is just egregious when they're thinking so like short term about companies that have already paid for like technology that reduces their mercury emissions. So it's already finished. Companies already have the technology to decrease their air pollution, and he's just undoing it so that they can challenge future rules by citing like how expensive it was to control while completely disregarding the future millions of dollars in healthcare costs for children affected with asthma and like respiratory issues that are going to be caused by all of this pollution. So just very disturbing.
Yeah, thanks, Carolyn. So in this case, just to get the technical details right, we're saying it's the EPA, which is the agency which works for the president. So they're part of the executive branch. And remember, like, I don't know if you guys remember at the beginning of the Trump administration, Trump appointed, was it Scott Pruitt to head the EPA? And he was the something from Oklahoma, Attorney General, Governor, I can't remember. But he had basically made a whole career of trying to basically sue this agency. So he hated the EPA. When Trump came into the presidency, he appointed Scott Pruitt to head the EPA. There's a very clear signal from Trump that he doesn't think the Environmental Protection Agency should exist and is valuable, right? So that's what, I mean, you want to sort of see the politics here. And so if you are a fan of environmental protection and the work the EPA does, that's disappointing. If you're someone that thinks the EPA and the federal government is overreaching and shouldn't be regulating in this space and should be doing everything they can to promote big business, then you like that. And so there's arguments on both sides of this in terms of the support for why the president and the EPA have gone this direction. But there's no doubt that Trump is trying to reduce environmental protection, reduce like air pollution regulations. And certainly, I think, Carolyn, the point you're making, when you look at like the cost to industry or the cost to public health, it's hard to justify some of those decisions from that angle. Does anyone else want to weigh in on this? Because this stuff has become really controversial and really, really partisan. Whereas if you look back at like the 1970s, people generally agreed like the federal government should protect clean air. If you even go back to the 1990s and early 2000s, people agreed the federal government should work to reduce, to stop climate change. And now it's become like a hugely divided issue. Anyone else have any thoughts on these regulatory changes or questions about what's going on here?
It wasn't explicitly mentioned. It was mentioned in the first article you sent that just went over like all the ones that have been changed. But there was the one, and there was like a kind of controversy with California set more stringent emission standards, and then that was changed, and then they sued, and now it looks like it was still implemented. Is that how that story went?
Sharon, I'd have to go back and reread that one to make sure
Okay.
I get that part right. But the Trump administration was trying to tell California that they couldn't set stricter emission standards or set stricter light bulb standards, and so they've been in court over those things.
I had a bit of a question. This is
Yeah.
Susan again. So I'm curious, are some of these rules still like in the process of being approved? And then if so, does that tie back into like the September 30th decision timeframe? Whereas if something is passed after that timeframe, then if a new administration comes in, then they could revoke those newfound rules? Or is that a completely different, like, is that just like with administrative law and stuff like that?
Yeah, it's a really good question and it's a complicated answer. So let me try to type this for those of you who are more visual learners at the same time. But there's kind of three ways you can get, like if President Trump was not elected again and Biden was elected president, we had a different, Biden's like very much focused on addressing climate change. So you could imagine that his administration, his EPA is going to want to go back to stricter mercury standards. So they're going to start doing rulemaking. So if you want to change the rules, and the Trump administration has made a ton of, like, thousands of rule changes through rulemaking. If you want to change the rules, there's three ways you can do it. You can start a new rulemaking. So you can start the whole process over again and basically say, like, okay, I'm just writing this in the chat box. Like, you know, I'm directing the EPA to revise the rules around mercury. They have to go through this whole process. We'll talk about the process in a minute, where they put out the proposed rule. They take comment on it for 30 to 180 days. They revise the rule. They have to do all this science. It usually is a 2 to 4 year process to change a rule. Maybe another way a rule can go away is that rules get thrown out in court. So the Bush administration did a lot of rules that the way they did them just didn't comply with the law. And so people would sue them, and then the rules would get thrown out in court. And when that happens, you go back to the old rule. So the old rule that was in place before it gets put back in place. A third way is that any rule in the last 90 days of a presidency can basically be overturned. This is some weird legality. I don't even know the details of the legal basis for it. And then the fourth way is that any rule within the last 6 months of a presidency, Congress can overturn. But that's not very common, but that happened after Obama left office and the new Congress was all Republican. They didn't like a lot of his rules. They overturned quite a few of them. So in this case, say Biden's elected and the Congress goes to the Democrats, they could overturn a lot of Trump era rules. Does this answer your question? This is we're like deep in the law here. Complicated stuff. Do you guys want to, I realize this is a super long and challenging discussion. Do you want to just go through the other PowerPoint quickly on the rulemaking process? Would that be helpful? Or of course, if you want to go, you can go. Does anyone else have any other questions, or do you want to talk about any other aspects of these rules?
So I have a quick question on that. Would it be to the benefit of congressional members to hold up passing anything, at least for the next couple of months, so that there is the chance to overturn it if the power structure changes in the government?
So Congress, it's a good question, Sean, but Congress has no power right now over rulemaking because rules and regulations all happen in the executive branch.
Okay.
So like right now, you know, we'll talk about this. The Council on Environmental Quality is changing all the rules under NEPA to like require less environmental impact analysis. And most people in Congress don't like it, but they have no power over it. It's something that the president and the White House are leading.
Okay.
Just remember that like rules interpret laws, and rules and regulations, there's like so many of them. There's so much detail. I'll show you some examples when we get to NEPA. Like if a law is 6 pages long, the rules interpreting it are usually like 100 pages long. There's just like tons and tons of detail interpreting every single word. What else? Are there other questions that are coming up or anything else you guys want to talk about? Otherwise, I can quickly go through the rulemaking process for you. Michael, this is a really good question. You're asking why environmental issues have become partisan. The Endangered Species Act, I would say that some of the burden of that law has fallen on large landowners and corporate developers. And because the Republican Party has become more like pro big business, I think that's one reason why that law has become more partisan. Partly it's because when that law passed, we didn't realize like how extensive extinction would be. So when the law passed, we were talking about like bald eagles and gray whales and things that everyone agreed on. But now we're protecting species like the American burying beetle. And they're like large farmers in Kansas that are like it's affecting their business, and people see it as unfair because like it affects a few small landowners who then, or developers, or like larger businesses that have to end up protecting species. And it kind of affects their bottom line, but not necessarily like everyone. So sometimes people will say, well, it's like causing cost to a small member of like rural landowners or rural developers. The question of why climate change has become partisan, I think, is a much bigger question, but has a lot to do with the role of fossil fuel interests in politics. So a much longer discussion.
I have a question about rules interpreting laws.
Yes.
I was wondering, so are the rules written while the laws are written? Are they written like when someone comes into a problem with the law?
Yeah, good question. So Kiana, on that, like the law I know the best, the National Forest Management Act, was passed in 1976. The rules didn't come out until 1979. So Congress passes the law, and then the Forest Service is like, oh gosh, we've got to interpret, like, what does biodiversity mean? What does timber value mean? What's a steep slope? Blah, blah, blah. What's a watershed? They have to go through like this multi-year process to interpret that law. And then they'll issue a draft rule, they take comment on it, and then they eventually issue a final rule. So years later, and then those rules came out in like 1979, and then the Clinton administration changed them, updated them. Then the Bush administration thought those were too environmentally friendly, so they changed them to make them more, relaxed. Then Obama changed them again. It's like happens with every presidency.
Okay, thanks.
Yeah, but presidents can't tackle everything, so they tackle the things that are priorities for them and their supporters. So, for example, the Trump administration, they haven't touched anything to do with forest regulations and rules. It hasn't been a priority. Okay, anything else? Okay, just gonna share with you guys one more thing to help you out with this lecture and rulemaking. So give me just a second. Are you guys seeing the title slide here? Kiana, you're the only person I can see. Can you give me a thumbs up? Are you seeing this title slide?
Yeah, I can.
Okay, so the other thing to really look for this week is like the detail on this law, the Administrative Procedures Act. Let me put this in full screen for you. So this is a law that passed in 1946, and it basically outlines how rulemaking is going to happen. And the whole point of this law is to make sure that when agencies are interpreting the laws from Congress, they keep the public informed, they allow for public participation, they have formal standards they have to use, and then the courts can review their work. And so the APA, Administrative Procedures Act, basically is a law from Congress. This is super confusing, but it's a law from Congress that tells agencies, when you do rulemaking, this is how you're going to do it. So I'm going to talk about this quite a bit in the lecture, but the APA dictates the rulemaking process. There's like 3 essential components. The agencies have to notify the public of an intent to make a rule. So last year, the EPA was like, hey, we're going to change the mercury rules and make them less strict. Then they have to take comment on that. The public can offer comment about what they think. They can offer science and things that the agency considers. Eventually, the agency puts out the final rule, and then the rule can be challenged in court under the APA. And there are a lot of different reasons you could challenge a rule, but the main one is, well, like if they didn't allow comment, then that would be bad. If the draft rule was so different from the final rule that you felt like they were kind of messing with you and they didn't really let you comment on what they were doing, that would get thrown out in court. Other things that can get thrown out in court is like if the rule that they propose is not, like it's interpreting a law from Congress and it's just going outside the realm of that law from Congress, like it's doing something Congress didn't even intend them to address, then that could get thrown out in court. So I want you guys, when you go through this lecture this week, to think about this process of rulemaking, that they have to put out a rule, they have to take comment. This is all in this lecture. And when rules come out, they're announced in this newspaper. It's called the Federal Register. It's online. And then they're eventually published in what's called the Code of Federal Regulations. And we have the most rigorous process for this in the entire world, and more citizen oversight over this than anywhere else in the world.
So the APA sets out what the rulemaking process has to look like.
Sorry, it just happens when I advance the slide. So this process is on this slide. They basically talks about how the public is informed of a proposed rule in the Federal Register. They take comment, final rule comes out, and then there's judicial review. So kind of go through this stuff.
The rulemaking process. So
I talk about, here's an example of a rule. So you'll get to go through this in the lecture. And then, you know, when you get to this in the lecture, the first part is from the National Forest Management Act. It's actually a law, and it says, Forest Service, we want you to provide for a diversity of plant and animal communities. And then I give you an example of the regulations, which are interpreting that, where the Forest Service says, like, okay, we'll maintain viable populations of existing native and desired non-native vertebrates. And so they're always adding detail about how they're interpreting the law. So this is all in the lecture. You guys can go through this.
Let's talk about.
But one thing I want to make sure you really pay attention to is judicial review. So the law from Congress, the APA, sets the standard of how courts can review all agency actions. And so anytime an agency makes a decision, like they're going to weaken the mercury rules, then people can sue them. So like, you know, the National Resources Defense Council is going to sue them for changing those mercury rules. And they're going to try to make the case to the court that the EPA didn't do something right. And courts are going to review for both procedural or substantive violations. A procedural violation is like they didn't go through some step they're required to by law, like allowing public comment. And a substantive violation would be like, maybe they missed the science, they actually got the content wrong. You know, maybe the act, the Clean Air Act, says the EPA has no jurisdiction over mercury. Well, that would be like a problem if they're writing rules about things that like they're not even allowed to in the law. So you guys will want to pay attention to this judicial review section. And then if you have questions next week, we can go over it again. And there's one more section in this lecture that this is what courts are looking for. They're looking for agency actions that are arbitrary or capricious. And arbitrary means like it's not based in fact, it's just being done with no logic. And capricious means they changed their mind, but they didn't explain why. And so this is what courts are looking for. They're not looking for, like there's other standards for other kinds of court cases, like innocent until proven guilty or preponderance of evidence. But when we're reviewing agency decisions, the courts are just looking for whether or not they're arbitrary and capricious. Like, are they really bad? Are they like really totally outside what Congress intended? And that's what, or do they like ignore the science? And that's what the role of the courts is. And so when you see an agency lose in court, you know they generally did something pretty bad, because the courts are deferential, which means they assume the agency is making the right decision and they're only looking for kind of glaring errors. So I'm going to stop here and just see if anyone wants to chat about any of this before class ends, because this stuff is pretty advanced and challenging. Does anyone have any questions on that stuff that you want to go over? Any like words that don't make sense? I'm using like tons of advanced jargon. So if there's anything that's not clear, we could talk about it. Okay, well, if your brain is just like fried, it's completely reasonable. But I hope this is helpful when you go back through that PowerPoint and look at it again. And if you have questions, come to our office hours, or you can email us, or you can write them down and bring them to class next week. But I'm really glad you all came today, because rulemaking, it's really hard to get the rest of the class if you don't get the stuff this week. So make sure you put in the time to wrap your head around it. And class gets more interesting in a couple weeks, I promise. This stuff is just like the foundational details that you need to know.